After a family watched their daughter with Down syndrome die over FaceTime, their landmark lawsuit against a Wisconsin hospital for medical murder moves forward. Next. Scott Schara is my guest. Thanks for being here again, Scott. Good to see you.
It's great to see you, Liz. Thanks for having me back.
We first spoke about what happened to your daughter. Absolutely tragic. Grace, she was just 19 years old when she died back in October of 2021 during the pandemic. She tested positive for COVID. You were worried about her oxygen levels at the time, thought she'd be better off in the hospital. That's, of course, what we were told back then. So she was admitted to Ascension's St. Elizabeth Hospital in Appleton, Wisconsin. Tragically, about a week later, she died. Of course, there is so much more to this story. And I do encourage people to even listen to our first conversation. I know you've been out there, done more than 1,000, I think, podcasts at this point. But tell us more about the moment, really, that your family knew that a lot more was going on and that you weren't being told the truth.
Yeah, that's an interesting question. So the night of Grace's death, so she had her first day in heaven on October 13th of 2021. And that evening, as you said, we watched her die on FaceTime. Her last moment was at 7:27. Immediately, Cindy and I got in the truck. I drove her to the hospital. I was extremely sick at that point, so I waited in the truck. And she was in the hospital for about 4 hours. They go through the entire process. It's not something I want to really drag people through. But on her way out, our pastor was pushing Cindy out in a wheelchair. And then one of the nurses had Grace's belongings on a cart, and she leaned down and said, "Mrs. Schara, me and several of the nurses don't think Grace should have died today." So then we had that under our belt. I ended up going into a different hospital 3 days after Grace died. They turned me around in 24 hours, and I was significantly worse than Grace. So we had that under our belt. And then the doctor friend of my wife and I that we talked with after Grace died, we were explaining things, and she said, "Scott, I think you should get the records." So through God's providence, I requested the records on October 31st. It was just 2 weeks after Grace died, and we had enough to piece it together 4 days later. That's a miracle just by itself. And so then what happened, Liz, and then I'll finish up with that answer to your question, but what really got us to that point. So now we've got the nurse saying this, the doctor and I started looking at these records, and we realized by November 8th that, okay, Grace was killed. We didn't realize she was murdered at that point. And then I sent all of our records and a report to Ascension St. Elizabeth's asking for a meeting with the doctor and the hospital CEO. This was on November 8th. On December 2nd, they wrote back and said, "We're not going to meet with you." So that was another, it's like, okay, what's going on here? Well, then I sent a complaint to the state licensing board that's called, in Wisconsin, it's called the Department of Safety and Professional Services, the Medical Examining Board. And they sent me a letter back on January 20th that said they did an investigation and the doctor didn't do anything wrong. So I sent them the details regarding the med combination, Precedex, lorazepam, and morphine that euthanized Grace, the illegal do not resuscitate order, and they sent back a letter that the doctor did nothing wrong. That was the first that I started to wake up. Before that, I would say that I had a general distrust for the government, but I didn't think that they were satanic. And I would have had a trust for the doctors, the white coat, just kind of going along with the system, the American dream, right? And at that point is when I realized, okay, there's something going on. And I really got into this doing now about 4,000 hours of research. So I don't even call it, in your open, you called it a pandemic, you called it COVID. I don't call it any of those things anymore because I don't see it through that lens. I see it as a complete psyop intended to deceive the American public to get the bioweapon jab in the arms of the public.
You've learned so much, and you've helped us, learn so much, I think, as a result of all of this as well. Your daughter, Grace, is put on a ventilator since then. Learning financial incentives were involved for doing just that. You also learned that a DNR, a do not resuscitate order, was placed on your daughter without you even knowing about it. And that has really led to so much of this research as well.
Well, interestingly, Grace wasn't put on a ventilator. And so let me just explain. We were under the impression that she had to go on a ventilator her first or second full day in the hospital. I challenged that and found out it wasn't necessary. Well, then we were pressured 4 different times subsequent to give the hospital a pre-authorization for a ventilator, which we denied. And interestingly, Liz, if we would have put Grace on a ventilator, given the hospital the pre-authorization to put her on one, I can guarantee she would have been on one because of the financial incentives. And then she would have died on a ventilator. Strangely, because of the PrEP Act, we would not have a lawsuit if Grace would have died on a ventilator. And zooming out, the ventilator was the standard of care during COVID, and doctors have immunity from liability if they follow the standard of care. Another, the DNR is a key element. We have 5 claims in our lawsuit. The DNR is a major piece of that claim. And it seems like everybody's in on it. I mentioned about the medical examining board earlier. They wrote us a letter that said the DNR statute in Wisconsin does not apply to physicians operating in a hospital setting. Wrap your head around that. And then we had a different attorney get involved with a criminal case, and the district attorney's office wrote back. I'm going to quote this, Liz, just so your listeners can understand how deep people are in on this agenda. This is what they wrote back to us. They said a doctor is not required to administer treatment she or he believes is not medically effective. This includes authorizing a DNR. The parties clearly had a dispute about how Dr. Shokar should treat Grace. Dr. Shokar did not abide by the wishes of the family. However, there is no law in Wisconsin that requires him to do so. Well, that's a complete lie. In the guardianship classes, and this is why I tell you the DA's letter is a complete lie. In the guardianship classes, they said that Wisconsin is what's called not a next of kin state. So NOT, not a next of kin state. So what am I talking about? Well, my background way back was, and I still am, a legal CPA, and I used to do estate planning. In estate planning, people would be familiar with the idea that if you die without a will, your assets go by state statute to your parents, your siblings, etc. Well, you would assume the same thing would apply in a medical situation. So just envision, Liz, you end up in a hospital this afternoon. You would think, just your common sense would tell you the hospital has to call your husband, right? Just logical. Well, in a not next of kin state, that's not true. In fact, the hospital takes over decision making in 15 states in our country right now. Minnesota happens to be one of those that is a not next of kin state. So that's the urgent message I have today. It's an easy fix. The easy fix is make sure you have a medical power of attorney in place, and the person that you assign as your medical power of attorney, or you pick as your medical power of attorney, make sure that they're awake to the system, because there is no document that can save your life. We had a medical power of attorney on Grace. The morning of October 8th, the hospital asked me for that power of attorney, and I gave it to them live via email within minutes after they asked. So they knew Grace's medical power of attorney was in place. So we were overriding the not next of kin statute, which is lack of statute in Wisconsin, with that power of attorney document. And so what this district attorney is referencing is simply a lie, because they don't want to prosecute doctors and nurses for criminal activity. Very frustrating.
It's taken about 2 years for you to prepare and file this lawsuit. Ascension's St. Elizabeth Hospital has denied the claims. Their attorneys have tried to get this case dismissed many times. Despite their efforts, a jury trial has been set now for June. How much of a landmark case is this, Scott?
It is quite an effort. I mean, we have multiple calls with the legal team every single week. I was just on the phone with one of the attorneys about 30 minutes before coming on with you because we're hot into depositions right now. That process of depositions is called discovery. Our family depositions are done, the doctors and nurses are done, our experts are done, and now we're moving into deposing their experts. I'm going to answer your question about the landmark purpose of this case. But what the next major date in our timeline is February 10th. That's when the defense experts have to be disclosed along with their reports. So then we're going to finally see what is their angle for countering our claims. So that'll be a big week to review all those reports that week. But the landmark nature of this case is based on a couple of different things. Number one, a jury trial. That is exceedingly rare. And as I've studied state statutes, I put together actually a podcast exposing this, because as a plaintiff, it is almost impossible to sue them. And I've got my arms around this at a level of detail I wish I didn't know. But I asked our legal team, for example, what is the ideal medical malpractice case? And they said a married man with children who's young and dies within 1 hour in the emergency room. What's the reason? Well, 1 hour in an emergency room because there's hardly any medical records. Married because there's state statutes that limit. So Grace was a legal unmarried adult without children. The state statutes say that she has, we have no loss of companionship because you have to have a spouse or children to have loss of companionship. That's where the big money is. Similarly, Grace was disabled, so she has no loss of income claim. Then we had a 1 week hospital stay. So when you start looking at this, and then they put limits on statutory damages. So for example, with medical malpractice, that claim, that piece of our claim has a statutory limit of $750,000. It's about, our estimate right now is $900,000 in legal fees to get through the trial. So it doesn't make sense mathematically. So that, hardly any of these cases ever see the light of day. Then most of them settle. What's the reason? Because they're on a contingency, and the trial itself will cost about $300,000. So they settle, and once they settle, there's a gag order in place, so nobody ever gets to hear what's going on. Then the main reason, so outside of all of that, the main reason that this has landmark potential is because we have a battery claim. And it's a very unique claim. Hasn't been heard in a very long time in medical malpractice cases because the state statutes really try to limit these claims. I'm going to quote something to prove that in here in just a minute. But that battery claim has the chance to go outside of the medical malpractice limits where the jury gets to write the dollar amount. So that has potential because attorneys don't take these cases on because there's no money in them. But if there is a chance for a jury to write an unlimited claim amount, more attorneys would take them on. So here's what's going on behind the scenes. And this, I'm exposing the details of our case, as you know. In one of the many motions to dismiss, I think there's been 9 or 10 motions to dismiss so far. The judge has not accepted any of them. But in one of the motions to dismiss, there's what all the attorneys came together on this claim for the judge to dismiss the case. And they wrote, the legislator's purpose in enacting a statutory scheme to govern claims for damages arising out of alleged medical negligence was to encourage healthcare providers to remain in Wisconsin by imposing certain limits on the causes of action that a patient or her family can pursue and the types and amount of damages that can be recovered. So you see what they're doing. They're putting a wall around these doctors saying, hey, doctors won't come to our state if they can be sued. Well, that's ridiculous. That would be, think about anybody that has no consequence for choices. What ends up happening? It becomes a slippery slope, and pretty soon, they're doing anything. And in the medical profession, they're actually killing people.
Well, as part of your efforts in this case, you've been able to make the depositions, the audio recordings, and the written transcripts, no video, but all available to the public. You've been releasing them on your website, ouramazinggrace.net. In doing all of this, what's been the biggest takeaway for you and your family from these hours and hours of depositions?
Yeah, that's really a great question. Interestingly, I was under a gag order, so they didn't want me to release any depositions. Praise God, the judge did not buy that. I have First Amendment rights. So the only videos I cannot release are the videos of the doctors and nurses and the defense experts. So I'm releasing videos of our family. I'm releasing videos of our experts because the videos are critical for people to see. And then along with that, the transcript. So the gag order, that whole idea, the gag order, that was a $22,000 diversion. But, you asked the question, what's the most surprising thing? I would say by far and away the lies under oath. The medical records, strangely, But you can understand why the medical records are considered prima facie evidence in a lawsuit, which means you've got to accept them as true unless you can prove otherwise. Well, thank God we were one of the few families in the country during the 39-month so-called COVID era that was allowed in the room. So because of that, and it was myself and my daughter Jessica, we both are note takers, and then we transcribed our notes. We have contemporaneous notes that counteract what the supposed truth in the medical records are. That's a big piece of the case. I have sat in all the depositions, less 3 that I have that I had a prior commitment, so I couldn't sit in them. But the lies, I mean, one of the doctors said, for example, that he sat down with me and discussed things Grace did, like golfing. Well, Grace never golfed other than mini golf, and the fact is I never met that doctor. But yet he's telling this story under oath. It's crazy. And, there's way bigger lies than that. Some of them I'm not exposing because we want to use them for trial, of course. But the other, I would say maybe the biggest one as far as surprises is doctors. 2 of the doctors use the excuse. Their names are on the medical the Precedex order, and they said that they did not order the drug, even though their name is on the order. They said under oath they didn't order the drug. So we dug into that. It appears that nurses can order these drugs and then use the doctor's name, and then they review it afterward for the sign-off. One that happened the last deposition of our expert said that if I would have taken Grace home with me on October 10th, and this is under the idea that they're trying to blame me for Grace's death. Our doctor expert said if Scott would have taken Grace home on October 10th when he was taken out by an armed guard, Grace would be alive today. The defense attorney twisted that and said to the doctor, well, that means because Scott didn't take her home, Scott's responsible for Grace's death. So, the idea that they want to blame me for Grace's death, I mean, I get it. That's, I guess, what their job is. But you would just think that people would have a little more empathy when, there's, my best buddy is gone. There's no empathy. Only one doctor out of all the ones that I met through this process even shook my hand and said, sorry for your loss, Scott.
I'm very, very sorry for that. You've faced so many hurdles, trial date set for June. You're talking about you'll be facing many more in the coming months. We'll be staying tuned with all these developments. I think you've opened so many eyes along the way. So God bless you for that, Scott Schara. Thank you so much for joining me.
Thanks for having me, Liz. God bless you.
And again, to learn more and to follow along with the case, please visit ouramazinggrace.net. Again, that's ouramazinggrace.net. That will do it for this episode of Liz Collin Reports. We'll see you next time.